Intellectual property protection and contracts. Intellectual property pertains to the ideas and theories that are distinctive and particularly valuable, including an innovation or creative work and the identification of who owns particular ideas or conceptions. You possess the right to create or license a new invention only if you hold the required intellectual property. Furthermore, specific differentiating marks can be used on packages or advertisements, and duplicates of original works may be published. Companies and individuals can license it from various owners without possessing intellectual property. Intellectual property is divided into patents, trademarks, and copyrights. Before starting to acquire a patent, trademark, or copyright, it is essential to understand the differences in protecting a company's intellectual property. A patent safeguards significant process inventions, excluding design patents. On the other hand, copyright covers both published and unreleased original works, such as literature, music, artwork, architecture, technology, and dance. The copyright holder, just like a patent owner, possesses exclusive freedoms and rights to duplicate, generate derivatives, distribution of copies, exhibit the work to the public, and perform it generally. Another fundamental difference between patents, trademarks, and copyrights is the extent of protection. Patents restrict others from creating or selling a particular invention. In contrast, trademarks usually protect the images, words, phrases, logos, and other gadgets used to locate the source of products or services against unapproved use. Trademarks grant the total authority for the owner to use specific slogans and pictures and prevent someone else from using similar marks. Otherwise, consumers might be confused about who created the products or services they purchased. Choosing between a copyright, patent, or trademark is influenced by the type of intellectual property an individual is trying to safeguard. Spulber maintains that it might not be easy to figure out the best strategy to protect intellectual property. However, this is particularly true in technically skilled fields such as industrial design and computer algorithms. Because settling on intellectual property complete protection necessitates serious thought, an intellectual property attorney might help you relax and ensure that your assets are adequately safeguarded. Registering your intellectual property with the government and enforcing personal ownership rights are the most significant ways to protect it. Individuals can preserve specific kinds of intellectual property in addition to authorization and implementation by detailing their discoveries. Furthermore, utilizing digital content, going for strong confidentiality agreements, and developing better access data are vital considerations in intellectual property protection. A contract's principal aim is to legalize new ties and lay out each party's different legal requirements towards the other. The majority of contracts nowadays are mainly involving businesses rather than individuals. On the other hand, contracts provide a variety of functions in addition to formalizing connections. Because of the extensive usage of contracts, there are several approaches in which a contract might benefit a company, provided it is appropriately managed. A contract becomes enforceable once both parties exchange something of value. As per Spulber, contracts are crucial because they help set standards and expectations for everyone who comes into touch with the organization. They provide legal support if one of the parties becomes confused or fails to fulfill their obligations under the contract. It is written evidence of an agreement, alternatively, it is what one party has agreed with the other party. Any business needs to get a binding contract for any agreement carried out regarding the supply, either for services the business provides, suppliers, employees, business partners, or self-employed contractors. Moreover, they should include all information, despite how little it appears to be. A contractual agreement involving private persons creates legally binding mutual obligations. Common consent, evidenced by a legitimate offeree, adequate compensation, capacity, and legitimacy are the critical characteristics of becoming a legal contract. Spulber states that a valid substitute can be considered in several states. General damages, exemplary damages, obligation damages, and specific performance are possible penalties for a contract breach. Contracts are legal promises that must be kept. Contract law is governed mainly by the state legal system. Still, although the general contract law is constant countrywide, particular court rulings of a specific aspect of the contract may differ. When a promise is broken, the legislation redresses the affected person, usually in compensatory damages or explicit contentment of the commitment, even though rare.